We are recording.
Thank you. Good afternoon, everyone. I'd like to welcome you to the appellate court. I am Judge Joan Alexander, and I'm sitting today with Judge Suarez and Judge DiPentima. This is the matter of Capone versus NIZZARDO, AC 42867. This argument is being conducted on Microsoft Teams platform. It is being live streamed on the Judicial Branch's YouTube channel, and the recording of this argument will be made available on the Judicial Branch's website. To the extent that there is any protected information involved in this case, I would remind counsel it should not be disclosed during the argument. To make sure we can all hear and see one another, I would ask everyone to please introduce themselves now, beginning with the judges, followed by counsel for the appellant, and then counsel for the appellee. I am Judge Alexander.
I am Judge Suarez.
And good afternoon, Judge DiPentima.
Good afternoon. I am Danielle Edwards for the plaintiff appellant.
Mark Katz for the defendant appellee, which is Buongiorno Children Red Barn LLC.
Thank you. I am confirming that I was able to hear and see everyone. If during the course of the argument you cannot hear or see everyone, please let us know immediately. Each of you received instructions prior to today's arguments. Are there any questions from counsel?
No, Your Honor.
I'm going to ask that everyone please mute their microphones when you are not speaking so that we don't get any feedback. You must also keep your camera on at all times during the argument so that we know that you are still present. If we have questions, we will raise our hands, and if you don't notice us doing that, then we will just jump in and interrupt you to ask the question. Everyone should be mindful that this is a court proceeding and conduct themselves as if they were present in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal, and the appellant should let me know before she proceeds if she would like rebuttal time, and if so, how much. Judge Suarez has agreed to keep track of the time and will notify you, each of you, when you have 2 minutes remaining and when your time is up. So, counsel, are you prepared to proceed?
Yes, Your Honor, and I would ask to reserve 5 minutes.
Thank you, and you can begin your argument.
May it please the court, my name is Danielle Edwards, and I represent the plaintiff appellant, BRIDJAY Capone. This is an appeal of a statutory partition in which the trial court was asked to determine a single issue: the buyout value of a parcel of land in Stamford that was inherited by the parties from their father, who purchased it in 1973. The parcel is 4.36 acres with a home and several equestrian buildings and structures, and it is divided in half by a road. The plaintiff owns an undivided 25% interest in the property, and the defendant, which is an LLC, has 3 members who are siblings of the plaintiff. The LLC owns the remaining undivided 75% interest. At trial, the plaintiff's expert, Michele, valued the property at $3 million. The defendant's expert, Adam Hardy, valued the property at $1.1 million. The court adopted the valuation of the defendant's expert of $1.1 million and ordered the defendant to pay the plaintiff 25% of that value, $277,500. There are 3 issues in this appeal. The first is an issue of first impression. Should a trial court be allowed to determine the value of a piece of land in a buyout partition without ever reviewing the applicable zoning regulations that state how the land can or cannot be used? The answer is no. At trial, both experts testified that the value of the land is based on its highest and best use. That is, the reasonably probable use that results in the highest value. Highest and best use is based on 4 criteria, according to the experts, and the first is legal permissibility. With regard to legal permissibility, both experts testified that the property is in a residential 2-acre zone called RA2. Neither expert included in their reports, however, the actual RA2 zoning regulations in place now, or that were in place in 1973 when the property was purchased, or any of the zoning regulations that were in place in the intervening years. And they also did not include any zoning regulations regarding equestrian facilities, commercial or residential, or variances. Moreover, yes, Your Honor.
Yes, Attorney Edwards, was there any legal argument, closing argument, or any post-trial briefs in this matter?
Yes, Your Honor. Both sides submitted post-trial briefs, and actually requests for articulation were also filed and articulations were provided.
But in terms of the issue you are saying is a matter of first impression, when was that brought to the court's attention?
This was not actually brought to the trial court's attention, Your Honor. But the issue of zoning regulations was discussed several times at trial. And first of all, the judge said on the record at the beginning of trial, "I don't have any idea of zoning." The judge also said that the buildings appear to comply with the Stanford zoning regulations. And at the close of trial, the judge said on the record to both counsel, "In the event that there is some need for me to contact the zoning regulations, I have the ability to do so, but it is probably not necessary." And counsel relied on the court's representation in that regard. And when a request for articulation was filed thereafter, asking the court to articulate the basis for its decision, the court again did not provide any reference to the zoning regulations, even though the court judicial zoning regulations counsel from the bench that it would consult the zoning regulations if appropriate.
But counsel, I guess my question is, you're framing this as a matter of first impression that we need to decide. And to decide this matter on a record that is devoid of counsel raising the issue before the trial court, to give the trial court an opportunity to speak on it, to rule on it, doesn't seem like the best scenario for us to do that.
Well, Your Honor, that's why we're asking the court to review this under the plain error doctrine. And that doctrine is a doctrine of not of reviewability, but of reversibility. So even if an issue is not raised in the trial court, but it requires reversal of the decision, the doctrine can be invoked by this court.
What is it about the regulations that you would like the court to address?
Yes, Your Honor. Well, there are three important aspects of the regulations. First of all, what does the RA2 zoning regulation in Stanford say now? We have no idea. We have no idea what it said in 1973, and we don't know what it says now. In other words, we don't know what is actually allowed in this zone as of right. We also don't know what, if any, zoning regulations govern equestrian uses, which was really at issue in this case, and what, if any, zoning regulations govern variances. Now, both experts stated expressly in their reports that were submitted as exhibits that they are not qualified as experts regarding zoning regulations, and they did not include the zoning regulations in their reports that were submitted. Yes, Your Honor.
So why didn't the parties call an expert on local zoning rules?
Well, Your Honor, it's not clear to me why additional experts weren't called. I will point out also, though, that the expert for the defendant included a section in his report to include the actual applicable zoning regulations, but they were never appended to his report. The experts did testify, though, regarding their opinions about what is allowed in these in this zone and what could be done on the property, but these amount to legal conclusions that were provided by an expert that isn't qualified to do that and really shouldn't be offering legal conclusions at all, because legal conclusions should only be reached by the court. And so the allowable uses on the property is really a mixed question of fact and law, and the law should have been provided to the court so that the court could apply the law to the facts. But the court never received the regulations and never looked for them itself, even though it acknowledged on the record that it could have. Are there any other questions about this first issue?
Yes, I just want to make sure I understood your argument about this. So other than the allowable uses that you say were not clear because you didn't have the regs weren't included, was there any other thing that you feel results in a manifest injustice to your client because the regs provide something that the court should have considered?
Well, Your Honor, the ultimate conclusion of the court, which is the value of the land, is based on its highest and best use, and its highest and best use is based on what the zoning regulations allow. Now, if the court had either received as exhibits the regulations themselves or had taken judicial notice of the regulations, then in this appeal right now, we would be able to look at the applicable regulations and determine whether the trial court committed an abuse of discretion in misconstruing the regulations. The problem that we have here, the plain error that we have here, is they were never before the court, never considered by the court. The regulations could say wild things that completely undermine the ultimate determination of the court, but there would be no way for this reviewing court to determine just how wild or unreasonable they were because they were never presented to the court. The regulations are yes, Your Honor.
Attorney Edwards, here's my problem with this. You are making this argument that should have been made to the trial court so that the trial court, I mean, it sounds to me as though you expected the lawyers to have to do nothing. That the trial court was given this stipulation and a narrow issue to decide, and apparently received post-trial briefs that said nothing about the regulations that you say are absolutely essential to its decision on this matter. And you're putting it on the trial court, and that's my problem, counsel. That's my problem with it.
I understand what you're saying, Your Honor, and I would direct you to our Supreme Court's decision in Delfino versus Valensis, which we've cited in our brief. And I think the reason that the trial counsel did not submit the zoning regulations is because there's no appellate authority saying that they needed to. That's why this is a case of first impression. But in Delfino, which is not, excuse me, yes, Your Honor.
Isn't Delfino, the question before the court was, what is the best way to partition that property, either in kind or by sale?
That was the ultimate question in that case, absolutely, Your Honor. But the regulations were just as critical there as they are here because they formed the basis for subordinate facts, which was which uses are permissible or likely to be permissible on the land, and therefore how valuable is the land. Now that case admittedly is not on point. We don't have anything on point in Connecticut, and so this is the closest case that I was able to find that touches on whether or not regulations should be required in a case where a court is determining the best use and disposal of the land.
So counsel, even though there's no law on it, you're saying it was plain error for the court not to consider the regulations?
Yes, I am, Your Honor. I'm saying that a trial court should not be allowed to determine the value of a piece of land in a buyout partition without reviewing the applicable zoning regulations.
Thank you.
Thank you. The second issue, Your Honor, is whether the trial court erred in determining that the highest and best use of the property is residential rather than as a commercial equestrian center. The plaintiff's expert determined that the best use is as a commercial equestrian center, while the defendant's expert said that it is purely residential. Now this property, which has more than 4 acres, has many improvements that were constructed beginning in 1920 and then improved over time. This includes barns, a converted barn that houses apartments and an office, a paddock, 2 stables with 23 stalls, an indoor riding ring. It has signs advertising things like horse boarding and pony rides. It has a rented single home, and altogether it has over 13,000 square feet of equine buildings, in addition to almost 4,000 square feet of a house. Now, historically, this was used as a commercial equestrian facility, and the smaller 1-acre lot was used to support the activities on the bigger lot with things like storing feed, manure, tractors, and equipment. This is also advertised as an equestrian facility, and the likely purchaser is someone who is likely to use it as it is advertised and it is as actually used, which is as a facility for horses, used as a facility for horses, and one that generates income. Now, the fact that the property generates income was admitted by one of the members of the defendant, who explained, the revenues that the property brings in. For example, the 2 stalls are occupied by horses, each of them for $975 a month. A tenant lives in the family home for $2,000 a month, and tenants also live in the apartments for a total of over $83,000 a year of horse and person tenancies. And in addition, a member of the defendant testified that the property is still actively marketed by them for riding lessons, birthday parties, camps, and special occasions for riders of all levels, and that they also currently employ a man to clean the stalls, to turn out the horses, and to clean up. All of this supports a conclusion that this isn't a commercial equestrian facility. It's an equestrian operation, and it's not actually a single-family residence. Now, the court's memorandum of decision was rife with factual errors about the conclusion of the highest and best use. First of all, the court never actually reviewed the zoning regulations about residential use versus equestrian use. And the root of the experts' disagreements was really about these 2 things. The decision doesn't explain, for example, why a property with only over 13,000 square feet of development for horses is best used as a residence, and it did not apply the law to the facts. And so therefore, the court committed clear error in this regard. Let's see. Are there any questions about the conclusions about the highest and best use before I move on to the 3rd issue? Okay. The 3rd issue is that the court collectively engaged in missteps that amounted to an abuse of discretion when it valued the property at $1.1 million rather than $3 million. Both experts used 2 different ways to value the property, a cost approach and a sales approach. A cost approach requires them to value the land itself, plus the structures on the land, appreciated or depreciated for value, and a sales approach requires them to find comparable properties nearby and then make adjustments for differences. Under the cost approach, the plaintiff's expert valued the land at in total at $2.6 million, and he adjusted the price per acre of the comparable properties based on size, public utilities, market conditions at the time of sale, the location and size of the parcel, and other criteria. He also made adjustments. Yes, Your Honor.
Your time's up if you want to just.
Thank you, Your Honor. I'll reserve my 5 minutes for rebuttal.
You can proceed, Attorney Katz. Thank you.
My name is Mark Katz. I represent the defendant appellees, As Your Honor will notice, the defendant appellee does not appear in the caption of the case. Brief explanation is that the 75% owners, 3 of the siblings in this unfortunate litigation, combined to form the LLC that was substituted as the party defendant and now appellee. I think it's important to note that this effectively was not a partition action. The partition part of the case was resolved by agreement of the parties, and the parties, defendant and plaintiff, stipulated that Judge Tierney's sole role, based upon the agreement of the parties, that this would be a minority interest purchase by the majority interest owner. Judge Tierney's sole role was to value the subject real property. And by the way, I don't believe post-trial briefs were submitted, but in any event, the parties stipulated and agreed that Judge Tierney's valuation would be a full and final resolution, and that was stipulated to in court and as part of the record. The plaintiff's pleading was amended. Paragraph 6, which is in the plaintiff's appendix at page 26, states a sale or partition in kind would not promote the interests of the owners of the property. And that was the basis of the stipulation. And the parties agreed on how the partition of the property would be resolved. Judge Tierney had substantial evidence. And the interesting part is, if Your Honors reviewed, and I don't think Your Honors have the time, but reviewed the 2 appraisals that were submitted, there's substantially in agreement on many of the criteria that the appeal raises. And one point in particular is this focus on zoning. There were 2 elements. One in the plaintiff's expert report, which appears on the appendix, plaintiff's appendix at page 109, zoning information. And the plaintiff's expert correctly classifies the zoning information as RA2, which is Stamford, Connecticut's 2-acre residential zone. And then he puts under zoning information that the current use is permitted. And the answer is yes. And then he says it is permitted per a conditional use permit. And then he states current use compliance, that it is a non-complying use. And then he states as to whether there's a zoning change pending, no. And that's in evidence. That was an exhibit in the case. Now, there's no disagreement as to anything he states as to those aspects. Appellant's counsel states to the court that Judge Tierney's ruling was that this is a residential property and he valued it as a residential property. That's not correct. If Your Honors look at the MOD at plaintiff's appendix, page 28, the judge ruled, quote, the highest and best use of the real property is the continuation as a residential use augmented by a supporting equestrian facility that has limited commercial viability, close quote. So the judge specifically found that that use was a continuing use and his valuation was based upon that use. So I disagree with counsel's characterization of the judge's finding and the fact that there was no zoning information upon which the judge could rely. And now, the Delfino case clearly is inapposite to the argument being made by appellant's counsel. And it's inapposite because the Delfino case clearly went to the methodology of how a partition should be structured. So zoning would be relevant to determine subdivision, the availability of subdivision, so that there could be either an in-kind partition or other form of partition. That was not of any relevance in this case. In this case, the methodology of the partition was agreed upon by the parties, presented to the trial judge as a minority buyout, pure and simple. And I go back to the full and final stipulation that the parties made that Judge Tierney's valuation would be a full and final determination that would allow this partition to proceed. And now, insofar as plain error is concerned, I think the missing, well, I'm not going to concede that there's any relevance of the doctrine here, but the fact that a plain error claim requires that the failure to grant relief will result in manifest injustice because zoning is directly correlated to the value of the property, which is the claim made in the brief by the appellants. There was no submission as to how that plain error occurred, other than by saying the court should have accepted the plaintiff's valuation, which was subject to the same infirmity of an absence of zoning as the defendant's valuation. So the plaintiff is arguing, the appellant is arguing, wait a minute, you have a gross undervaluation here, while at the same time arguing there were no zoning regulations taken into account by the judge. Well, that applies to both appraisals. I think the simple fact of the matter here is it's very clear from the record, the totality of the record, that the parties agreed that Judge Tierney would value the property as it sat, that there was ample evidence from both experts that the property was in use as a mixed use residential and equestrian facility. Judge Tierney accepted that, entered a valuation based on the appraisals. He accepted the defendant's appraisal. He did not accept the plaintiff's appraisal. And for the appellant to argue he should have accepted the plaintiff's appraisal, the appellant's appraisal, while at the same time saying the same defect existed in Judge Tierney's ruling at all, it is inconsistent and to my way of thinking, not acceptable. So I would simply argue to the court that the parties stipulated and agreed. Judge Tierney's determination of valuation was full and final. He had ample evidence of zoning, even if that were relevant. He valued the property as it sat. The evidence was it's a residential property with an equestrian facility. The plaintiff appellant wants you to hear that it was an equestrian facility with a residential use. but there's been no explanation as to why that would make a material difference here. The appellant also ignores Judge Tierney's examination of the numerous defects in the plaintiff appellant's appraiser's comparable sales. Both appraisers used comparables. The appellant expert went to upstate New York and far and wide outside of the area of Stamford, Connecticut. And by the way, that page A109 also contains information as to the tax assessor's valuation of the subject property, and that tax assessor's valuation of the subject property that was put in evidence by the plaintiff was $1,947,747,014, and the Judge Tierney, it came in at $1,100,000. And so in their own exhibit, they put in the tax assessor valuation of the real property, which was almost identical to Judge Tierney's valuation. So I think that to burden or saddle the trial court with the examination of zoning regulations when the parties agreed, value the property as it sits, which is exactly what he did, and then to argue their appraisal should somehow be given weight or merit, I don't accept. Thank you.
Attorney Edwards.
Yes, Your Honor, thank you. I just have a very brief response. First of all, I'd just like to point out that the appellee did concede to the standards of review and did not dispute the standards of review that we did set forth in our brief. The second is with regard to the court's misunderstanding of Michele's analysis. That was pretty significant. We've outlined it in detail in our brief, but I'd like to point out that the court, first of all, said that Michele's land valuation did not justify the value of the land, but his land valuation was only half the value of the land under the cost approach. The other half was the improvements on the land. So of course that wouldn't justify a complete cost value of the land, but it was really only half, and that's very clear in the report. The second is under Michele's sales approach, the court also said that relying on the raw data for comparables, it didn't justify the final valuation because they were unadjusted, but Michele's analysis clearly shows that he did adjust before he came to his final valuation. The court also stated that his highest and best use conclusion was actually a vacant lot, but that's not true. Michele never valued the property as though it was vacant, and he only said that if it were vacant, its best use would be as a residential lot. But because it has so many equestrian improvements, he concluded that the best use is continuing to improve it, to use it as improved, which is as an equestrian facility. And then just with regard to the zoning regulations and the fact that they weren't submitted, I would just reiterate also that both sides' experts opined about what the regulations do and do not allow, but it isn't appropriate for the court to rely on those opinions. Not only are they not qualified to opine as experts on this, but that's really the function of the court and not as an expert. Because of the collective mistakes in this trial, where the trial court did not review the zoning regulations, it very clearly did not conclude the highest and best use of the property. It misunderstood grossly the valuations provided by the plaintiff's experts, and ultimately arrived at a valuation that was just 1/3 the plaintiff's experts. The only resolution here is for a new trial, and so we respectfully ask that the case be remanded for a new trial. Thank you.
Counsel, Attorney Katz indicated there was no post-trial briefs, and when I looked at the appendix, I did not see any. Is that correct?
Yes, Your Honor, and I do apologize. I had a note to say that Attorney Katz is absolutely correct. There was a bit of post-trial motion practice because of the multiple requests for articulation, and in my mind, I confused that with briefing. I do apologize. Thank
Not
you.
a problem. I just wanted to make sure we didn't miss some part of the record as well.
Attorney
Thank you.
Katz is absolutely correct.
Thank you. Well, thank you both for your argument. We will take this matter under advisement, and we are in recess until 4 o'clock. Thank you.
Thank you.